All right. All indications are we are live, and I'm getting better at this, Jake. This LinkedIn Live and
We are allegedly
YouTube,
live. I like to.
YouTube
I'm gonna
Live,
start. I'm gonna start saying allegedly. We're
allegedly.
allegedly low. I don't actually know.
Yeah. Well, I got the little dashboard here, and StreamYard is saying we are live. So nice. All right. So I think we're all set. We've done all our show prep. We are ready to go. I'm going to count it down. 5, 4, 3.
So, Kip, what are we going to talk about today on episode 198 of the Cyber Risk Management Podcast?
This is one of those podcasts that I really enjoy. Thank you for putting this together. This is where we're going to take a really interesting lawsuit, and we're going to look at what happens when a HIPAA business associate agreement gets tested in court after a ransomware attack. And for those of you who are watching, you can see that the episode title is "Breaches Within Breaches," and I love that. And so we're gonna take a look at this lawsuit. I love lawsuits because they let us see things that we normally don't get to see when there's a cyber breach of some kind. I love doing cautionary tales. That's what this is. We're going to talk about contractual obligations, incident response, and the importance of actually performing the security controls that you promise to customers and others. So, Jake, this is great. Why don't we start with the basics? Take it away.
Sure. So this is this case is between a company called Molecular Testing Labs. We'll probably end up calling it MTL. It's a medical diagnostic laboratory, right? We all know these types of companies, right? But importantly, it's a HIPAA covered entity. And it's a HIPAA covered entity because it engages in HIPAA covered transactions, billing insurance, for medical, well, in this case,
Okay.
medical testing, obviously.
But they're not a HIPAA covered entity in the old sense, right? Which is to say,
No, they
they're
are.
they're like an outsourcer to the medical community, right?
Um, so it's interesting. Medical labs fit into an interesting space. They're technically they technically have always been covered entities.
Okay.
Because they are effectively a form of healthcare provider, right? They are
That was the word I was
conducting,
searching for.
yeah, healthcare provider.
Got it.
So no, they are. It's a medical diagnostic laboratory, but it's a healthcare provider. They're independent. They don't owe allegiance to a hospital or a group of physicians. They're not a subsidiary. They are an independent entity, and they are an independent HIPAA covered entity. So
Okay.
that's
Sorry
kind of
about the
yeah.
diversion.
No, that's it's worth it. It's HIPAA's very confusing. We've talked about it before. I'm sure we'll talk about it again. Okay, so the other company who goes by the name of Entirety, which is just capital N TIRETY, Entirety.
Took me a moment on that one.
Yes, is their managed services provider and business associate under HIPAA. So let's just break that down real fast. Everybody listening to the podcast knows what an MSP is, managed service provider. Now, a business associate is actually a defined legal concept under HIPAA, and it is a service provider to a covered entity. And you have a BA, which is what we call a business associate, has independent kind of obligations under HIPAA, and the covered entity and the BA must enter into a BAA, which is a business associate agreement. These are not new. These have been floating around for, at this point, I think literally decades.
But what's interesting is in the cybersecurity sphere, we don't always get involved in that because these are really contracts, and it's more in the legal world and the contracts management world.
Yeah, and
so
I don't know why, because a BAA is fundamentally about compliance with the HIPAA security and privacy rules. And frankly, more so, both, right? We talk as if they're separate.
I've just noticed that in my work.
No, I'm not disagreeing with you.
Yeah,
You are
they
correct.
are handled
I guess
separately.
what I'm saying is that we should draw a line in the sand as of today or whenever this airs, that you really shouldn't do that. A BAA, though it's old, really needs to be looked at by the security team. And I'll add this: we did do an episode, and Kip, I'm sure you'll dutifully link it in the show notes at some point.
Yep.
About the potential updates, the proposed updates to the
Yes.
HIPAA security rule, right? If those go forward, if those are finalized, then a BAA is going to get even more detailed, and it's going to become even more of a cybersecurity operational issue. So it already is. Like, don't get me wrong, but
Okay.
it's gonna become even more so in the potentially not too distant future. So, okay, here we are. These two parties, MTL and Entirety, entered into this BAA back in September of 2018. Now, the BAA, like all BAAs, was supposed to ensure that Entirety would establish and implement appropriate safeguards for the protected health information it handled on behalf of MTL. And if that sounds a little bit like a canned phrase, it kind of is. There's many different ways of saying it, but that is the purpose of a BAA, is to ensure that Entirety complies with the HIPAA security rule, which requires them to establish and implement these safeguards. So,
and it puts them on the hook, right?
Oh, yes, for sure. We'll get to that.
Okay.
Okay, so fast forward to 2025. MTL receives information about a material data breach involving data that Entirety was supposed to be securing under the BAA. Now, this is already bad news. But then MTL launches a forensic investigation and determines that, shockingly or not shockingly, Entirety had suffered a ransomware attack. The article and the complaint both say potentially from Russian threat actors. The reason it says that is the presence of Cyrillic characters, which is certainly suspicious. I wouldn't say it's determinative.
It could be a false flag, but yeah.
Yeah, I mean, there's who knows. It almost doesn't matter, right?
Right.
And now this is the frustrating part about trying to do news reports on complaints, is that the allegation is that Entirety had, quote, significant deficiencies, shortcomings, and omissions, end quote, in its procedures and practices that enabled the attackers to access Entirety systems and therefore MTL's confidential information. Unfortunately, we don't have a ton of detail because the complaint doesn't have a ton of detail, and the case is not moving. Well, I mean, it hasn't gone very far yet.
But still, I mean, we're getting an initial peek at this.
Oh, we're certainly getting an initial peek, and frankly, we can probably guess, not that we're going to on this episode because it doesn't really add anything to the analysis, but the fact is that they fell victim to what was probably a pretty standard malware gang and attack style.
Yeah. Okay, so this is sounding pretty bad so far, but in our style, it actually gets worse, doesn't it?
It does.
Okay, so what happened after the breach was discovered?
So okay, that's where things get really, I mean, I guess interesting, sad maybe.
Sad. Jeez.
Sad. I mean, you're just like, oh, you see enough of this, you're like, come on, guys, come on. So okay, according to MTL's complaint, Entirety, quote, failed to provide material support to MTL for weeks, end quote, after the breach was discovered. The support they did offer was allegedly provided, and I quote from the complaint, slowly and incompetently, end quote.
Oh my goodness.
And
now I understand sad. Okay.
Now do you understand sad?
Yeah.
And here's why I'm just like almost facepalm level. Entirety informed MTL that it would be charging MTL for its incident response efforts. There you go. You actually facepalmed. See that?
I did. For people who are listening to this and don't see the video, I facepalmed. I didn't even think about it.
He couldn't. Yeah, he didn't. That's the best part, is he couldn't help it, because even though I literally just said that like you did it anyway, which is actually extra funny. So where we're going with this, MTL argues that under the business associate agreement, Entirety was required to support MTL in its efforts to respond to and mitigate and remediate the security incident's harmful effects. Pretty standard.
Yep.
So not only did Entirety allegedly fail to maintain adequate security, but then they also allegedly failed to properly assist in the response, and then tried to charge for that incompetence. Not a great look. And yeah.
Well, and man, one of the reasons why I face palmed is because, I mean, based on the feedback that I hear when I'm talking to different customers that I have, I mean, nobody really likes their MSP. As a group, they don't seem to have very strong reputations.
It's a tough business,
It
Kip.
is.
It's a tough business. I think it's one that arose for a pretty clear market purpose.
Mm-hmm.
Um, it's a tough business. I
It
don't
is
really
a
know.
tough
There's
business.
really no way to say it.
Yeah, but things like this don't make their reputation any better. And then we get to the part about the fact that the business associated agreement, the BAA, there was very specific language in there that they signed off on, and then they tried to behave in a way that was completely contrary to it.
Well,
How do you get out of that? I mean, that's like
so
people
you
are not paying
probably
attention to what they're signing, are they?
well, so okay. Now we're entering into speculation land here for a moment. So this is going to be
But that's what
outside
makes the episode fun.
It of course, and besides, people expect that of us. But you know what? We don't. I mean, it's speculation with respect to this particular case. But you and I both know for a fact that BAAs are one of those things that gets tossed around. In my opinion, way too often. They oftentimes will get signed even though HIPAA doesn't even apply. I haven't done the full legal analysis on whether or not that matters. Like I actually don't think you can force compliance with HIPAA if it doesn't apply. Anyway, it almost doesn't matter. People sign these things because they think they have to without really reading them.
What do they call it? Performative or something like that? I don't know. There's a word. Anyway, yeah.
So I think the one of the issue here is costs, and fundamentally this is a breach of contract, right? That's the point of a business associate agreement. It is a contract, and what matters is the specific language that any BAA. So if you have BAAs, you should look at this. What damages is MTL claiming?
Okay, so I've looked at this, and I can walk us through it.
Yeah.
So what I saw was significant costs and multiple areas. So let's go through it. So MTL's already incurred expenses for the forensics investigation, right?
We expect that. Yep.
Mm-hmm, yep. That's pretty straightforward and expected. They're anticipating costs associated with fulfilling the HIPAA breach notification requirements and providing credit monitoring services to affected individuals.
Yep.
Of course, MTL is also expecting harm to their business reputation, and they themselves are expecting lawsuits, regulatory action against them. So there's a lot that is either happening to them already or they really expect is going to happen. And I think that naturally they turn to their BAA because guess what? There's an indemnification provision that requires entirety to indemnify, defend, and hold harmless MTL against losses and expenses due to a breach caused by entirety's negligence. Now, by the way, I'm not an expert in indemnify. What does it really mean to defend and hold harmless? But I can tell you, as a small business owner, I stop when I see things like that in contracts people ask me to sign, because I just get, dollar signs start dancing in my head if something awful happens, right? Like this could really destroy my business potentially.
Yeah, and I think one of the reasons I wanted to do this episode is so that I could go into Professor Jake mode and talk a little bit about indemnification, this little phrase, indemnify, defend, and hold harmless. And we've definitely talked about security theater on this podcast.
Mm-hmm.
I've lost track of how many times. If we had like a full transcript, it would be entertaining to see like how many times certain catchphrases come up.
Actually, that's not hard to do because every episode we've ever done is transcribed on our website.
Oh, well, that would be excellent. Maybe we'll have to do that at some point. But
we could point Claude Sonnet 4.5 at it, and I'm sure it would do.
Well, we could. I'm sure we could. So I'm going to introduce perhaps not for the first time, I honestly don't remember, my concept of indemnity theater or indemnification theater. And this is a really important concept because something you said a minute ago, Kip, I want to dig into that just for a moment here, which is, yes, they have this indemnification provision, but you also said that MTL in this case is expecting themselves to be sued or be,
Yeah.
or face regulatory action. And there's going to be people listening to this podcast who are at least tempted to think to themselves, well, that's not fair. This was obviously Entirety's fault. And to you, I say you are correct. However, from the regulator and responsibility for the data perspective, the buck stops with
That's right.
the business, the data controller. And I know we've said this before, but it's worth repeating, and frankly repeating over and over again. Most breaches these days are probably caused by a third-party vendor of some kind.
Oh yeah, and we've got plenty of data that
so much data
proves that.
But you're on the hook. The party who is buying, who hired the vendor, is on the hook for that.
Yeah.
And you're on the hook for that no matter what. Now, so let me explain then what indemnification actually does, right? This little phrase, indemnify, defend, and hold harmless. Now, look, we could write law review articles. Law review articles have been written about whether or not those are all the same. They aren't, right? Those actually are three potentially distinct legal concepts. However, they do often get run together. And for purposes of this podcast, which is not a scholarly legal publication, what I want to focus on is the idea of indemnification and defend.
Okay.
So if you get sued, Kip, you need to hire a lawyer, right? And you're going to start incurring costs right away. Now, if you are lucky enough to have somebody out there who owes you a defend, has promised to defend you, and it's somehow their fault, turns out that's great news, because what that means is they will actually come in and hire and pay for the lawyer. That's a big deal, because it means you aren't necessarily immediately incurring expenses directly to you, right? Now, the reason why indemnity and the defend are different is that indemnification is really a cause of action that you can use once you've been injured. You make an indemnity demand or an indemnification demand to be made whole by whoever owes you that obligation. So these are different things, right?
Okay.
The defend is like insurance companies, right?
Yep.
Like when you submit, I mean, typically that's who owes you the defend, right? Is the insurance company. That's the whole point, is that you don't want to have to pay for your defense. So the insurance company comes in and does it. And that's the whole insurance defense legal industry and all that stuff, right? But the indemnity is different. And the indemnity comes into play. You've suffered damages and you want someone else to pay for it.
Okay.
Right.
So in this case, like if I have reputation damages, right? Or
your forensics damages, right? So that doesn't the defend is actually very specific. Defend a lawsuit, right?
Okay.
If there's not a lawsuit, maybe also potentially a legal investigation, but for sure a lawsuit, right?
Okay.
Defend just generally, at least not to my knowledge, I've never seen this done. Defend would not mean on its own cover the cost of a forensic investigation, right? So that might be an indemnification issue.
Got it.
And so that's what's going on here, right? So
there's a lot at risk here.
There's a lot at risk here, right? So now you mentioned that, you said the BAA here included this indemnification provision.
Yep.
So what MTL needs to do is send a formal demand for indemnification to Entirety. That is the mechanism by which you say, I've been hurt, it's your fault, and under this contract, you promise to indemnify me against harm caused to me that was your fault. Hence, I'm calling you out. Come do it.
But Entirety didn't give any substantive response.
No, they did not. According to the complaint, Entirety provided no substantive response to the demand.
Yeesh. Okay.
So So here we are. We see the full cascade of costs that follows a breach: forensics, notifications, credit monitoring, potential litigation, regulatory
Hmm.
action, business impact, everything. Uh, this is why covered entities need strong BAAs with actual teeth. So let's go through some of the key lessons for our listeners.
Yeah.
What do you want to start with?
Okay. Well, there's so much here, and we haven't even really delved into this case, and already we can learn some things. So, um,
Well, and spoiler alert, there's not a whole lot more detail for this case quite yet, but we are
I
going to be getting
I,
into it.
I know, but you sent over the two complaints. I looked through them. There's a lot of what I want to say granularity, right?
Yeah.
It's like,
Well, to be clear, sorry, just to be clear, I sent you the complaint and the answer. So that
oh, and
was
the answer. Okay.
the answer is the defense side's, and it usually just says "nuh-uh."
I know, but there's all this juicy little detail in there,
That's
you know?
true.
I mean, and that's the stuff that kind of makes it real. Like, when somebody says, they've provided no substantive response, we can go and read it, and you can go, oh yeah, that's that's silly. Okay, anyway, but let's look at some takeaways. So the first one is that if you have a business associate agreement, you have to clearly spell out the security obligations of the business associate, because it's really not enough to have generic language about appropriate safeguards. And I know safeguards is like a word that you're like irritated by, Jake, and you want
I
specific requirements
I've
that
I've
align to
accepted
the.
I've accepted the phrase
Oh, you've
safeguards.
gotten
I
over it.
just
Okay.
I'm done. I'm not going to fight it. Like controls, safeguards, I don't care. Whatever.
Well, that's like me going cybersecurity. No, I'm not going to say I'm a cybersecurity person, but I lost that battle a long time ago too.
Long time ago.
Yeah, long, long time ago. But okay, but listen, you got to have specific requirements in your business associate agreement that align with the HIPAA security rule. You don't want vagary in the agreement because that just causes trouble downstream. All right, so that's the first thing. So the second thing is, and that means don't get a BAA off the internet and sign it. Oh my goodness. Okay, so the second thing is incident response obligations. Again, needs to be crystal clear. Things like what support must the business associate provide? And I mean exactly. And then who pays for what and how quickly do they have to respond? And these details matter, right? Because when you're in crisis mode after a breach, like you want people to leap into action, but if your business associate agreement doesn't really make that completely clear, then the person can just take their time, or show up late with virtually nothing to help you. And the third thing is that these indemnification provisions, as we've already kind of unpacked a little bit here, but they're crucial. Again, the need for clear language, who's going to bear the financial burden when things go wrong. And you have to remember that indemnification is only valuable if the party on the hook actually has the resources to pay. And that's why I, as a small business, am often obligated to show proof of insurance. Because if I sign a contract that says I'm going to provide up to $1 million of indemnification, but I have no way to pay that, well, that's a false sense of security
It
on the other
is.
party.
And that in a nutshell is the indemnification theater that I warn about, which
Mm,
is, you can get, someone who's too quick to just agree to indemnify you. Um, I mean,
without the means.
they could be it could be a routine business matter for them, and they do it all the time, and they have tons of money, and it's no big deal, or they don't know what it means, or they know what it means, but they need the business. You just don't know, right?
Right.
You got to that's got to be part of the
There's a
diligence.
lot of people who sign contracts with not really thinking so much about them because they're
Yeah.
just so revenue focused.
Yep, that's exactly right. Okay, so there's another lesson here about communication during a breach, and both the articles that I read about this and the complaint itself, um, all noted that it's unclear how or from whom MTL received information about the breach.
Hmm.
So it's quite possible that if it didn't come from Entirety, uh, I mean, that's generally a requirement. Now, maybe Entirety didn't know. That seems unlikely. Usually, if you're a victim of a ransomware attack, you did know. Of course, in the answer, they deny all of this and they say that the servers in question weren't under Entirety's control or custody and what have you. So, it's there's not a. I mean, it's unlikely that we'll get like a whole bunch of super great detail and like things that we can learn from this case. But the fact that the lawsuit was filed and that a responding pleading was done is a good reminder that it happens.
Yeah, and I wouldn't be surprised if MTL found out about the ransomware attack because they had a service outage, right?
That could be it.
Entirety is supposed to provide IT services, and if those services aren't functioning, then you naturally are going to wonder, why the heck do my computers not work the way they're supposed to?
Yeah. And I mean, and I agree, right? Typically, frankly, it doesn't matter if you're the covered entity or the business associate. You typically need to understand what your contractual requirements are after a breach.
Yeah.
A lot of people don't know. I mean, if you've done tabletops, Kip, then you might know, because you'll have gone, someone will have taken you through this exercise and you would have at least thought through what you might do. And, I hope nobody scoffs at tabletops these days, but if you are a scoffer at tabletops, then it's the equivalent of saying, well, there's no point in military or firemen or police doing any training at all. What's the point, right? Because there's just no value. It's not real. You're right. A tabletop isn't real. It's no more real than a war game or any of the other stuff. But you do, in a crisis, you do what you've trained to do.
Yeah.
And by definition, military, police, and fire services are, when they're called into action, it's typically a crisis by definition. And the fact is that incident response is also a crisis. And if you have not trained, then you might not know what to do. And this is one of those simple things that you learn very quickly doing, usually in your first, maybe second tabletop, is what are our requirements? What's our notification timeline? And can we make it, right? So BAAs typically do require notification on a specific time frame, somewhere between 24 to 72 hours after discovery of a breach. Honestly, I think you also need to, even if you don't have a contractual requirement, if you're a service provider, you probably should say something to your customers.
You'd think so, right? You would think so. And if you're a publicly traded company, I mean, you're going to have to notify anyway. So
you will. You will.
Now, TTXs, I got to say, they have a bad rap because, quite frankly, they haven't historically been done very well. I think
that is an issue.
The people doing them are, not doing them in a very compelling way. However, that doesn't mean you shouldn't do them. This is one of those things where I tell people who are decision makers, I'm like, look, a TTX is, you just have to eat these vegetables. I get it. You don't like eating vegetables. We want to go eat candy and chocolate. I understand, but sooner or later you got to eat your vegetables. So you can eat these vegetables, which are not many, or you can wait and eat them when they come by the truckload and they're soggy and cold. So anyway, now
and Looney Tunes style, shoved down your throat with Daffy Duck like jumping on top to shove them down. I mean, it'd be bad.
Yeah, but I think that's an apt, image to put in people's heads.
No, and I think it is absolutely a correct image.
Okay, so and then communicating about incidents at a high level, make sure that you do that because hey, it could come around. The news could be leaked somehow, and then if there's any one thing people hate, it's being surprised by bad news, especially when it comes from a third party. Unfortunately, we have a lot of data that shows that most victims of breaches find out from third parties. Which is awful, right? Now, there is a balance that you have to strike, though, between being fully transparent versus not saying too much before you know the full story. And
that is true. I totally agree with that.
And I know I've seen in TTXs, I've seen the public relations person saying things like, "No, we have to be more transparent. We have to share more information," right? And then I've seen like legal counsel say, "No, don't do that because that could expose us to liability and that could really hurt us in court if we ever end up in court." So
plus the other part of it is, you don't know if that's the full story. Like that's
Right.
the main issue here, right? The
Yeah.
main issue with like transparency is generally good. Like I like transparency, but transparency, like you can't what's the phrase my wife's been saying, the phrase you can't put the toothpaste back in the
Back in the
tube,
tube.
right? And that is such an
Yeah.
apt phrase here, right? If you say something wrong, it's real hard to later go back and shove that back inside and be like, oh,
Yeah.
never mind, just
It
kidding.
is. So one thing I tell my customers is, okay, look, you should make a decision ahead of time before something awful happens. Are you going to lean towards transparency and create your plans around that, so you have holding statements and ways to be transparent without misstepping and saying things you can't take back? Or are you going to lean towards, saying as little as you can get away with for as long as possible? And are your holding statements and your plan designed from that perspective? Because figuring it out in the moment is a bad idea.
Bad idea. So um, let's also come back and I know we've been saying it a bunch, but just underscore why vendor risk management is so critical. And look, we've already mentioned this. When you're a covered entity, your business associate security failings become your problem under HIPAA.
Yeah.
You can have the best security program in the world, but if your MSP drops the ball, you're still on the hook, right? We've all said this.
And it's not just
Now,
HIPAA, it's any
no,
regulatory
it isn't
regime.
just HIPAA. Now, this is something that we don't talk about as often as maybe we should, Kip, which is the concept of ongoing vendor monitoring. And I don't have a good answer here, and I don't know that you do either. But like, I do know, like on the one hand, I know you can't just sign a BAA, 6+ years ago and assume everything will be fine. But what else can you do, and what does that look? You've face palmed again. That's 2 in 1 episode.
Yeah. Because as soon as you said that, it reminded me that in my book, and when I talk to people about this, I say, I get it. It's fun to be on the happy path all the time, right? I'm going to make this investment. I'm going to do this partnership. I'm going to, take this risk, and everything's going to turn out, and we'll be profitable, and we'll grow, and everybody will love us, and I'll finally get that jet I've been thinking about. But if you don't take a moment to think about what could go wrong, that's really what we're saying here, right? Negative visualization is one way to think about it. And this is something Aristotle was trying to teach us from, millennia and millennia ago, is you have to at least think about what could go wrong. And then, can I test that somehow to see if it'll go wrong? Should I just have a plan in case it goes wrong?
Yeah. Our mutual friend Adam Shostak has become the expert on threat modeling, which is just negative visualization.
That's right. I was given a talk to about 200 credit union board members and senior decision makers just last week, and I said to them, "Look, you don't need to be an expert in cyber risk to ask great questions. Like, you don't need to know how your data backups are happening, or what vendor you're using, or how you configure it. None of that's important. What's important is that you ask the question, what are we going to do if the backups don't work? And how do we know that they do work?"
Yep.
That's all, right? So ongoing monitoring can just be as simple as that.
It can. And let me ask you this, Skip, too. I mean, I think the concept of I know CMMC or something related to it has the concept of continuing. It was FedRAMP has the concept of continual monitoring or continuous monitoring. It's not really the same thing. I mean, it related, but my question for you is, and I know we've talked about this with some of our mutual clients. Like, what can you actually do? Like, you're not going to do pen tests on your third-party vendors, right? You can ask for SOC 2 reports. You can always. You should, before you onboard them, do some kind of security assessment and maybe even require evidence of specific controls. But Kip, there is a major, I would just say, general market failure in this space, because you and I both know, having been on both sides of these issues, that some SOC 2 attestations are worth the paper they're printed on. Some maybe aren't. The same with a security assessment, whatever that even means. For is it just a questionnaire? And then we do want to talk about the MSP perspective for a moment. And by the way, I do want to say, I have no idea if Entirety is liable for this or not. Right? We don't know.
No. We just have two people in conflict.
We just have a complaint and the answer in a lawsuit. That's all we have. But and we already agreed that being an MSP is tough, right? I do think though that the MSP needs to understand that HIPAA obligations are real and enforceable, and that the BAA will be used. But before we kind of move on to that and start to wrap up the episode, I do want to press you, Kip, in your we'll just say your venerable years of experience. Have you even seen the beginnings of a workable kind of vendor monitoring
Yeah.
framework?
Yeah, well, a framework, no, not a framework. What I've had to do though is I've had to think about um, testing claims, right? So I guess, if you want to think of it that way, how do you test these claims, that are contained in these contracts? And I'll give you a non-business associate agreement example, but I think is illustrative. Woo. So you and I have a joint client, and they have outsourced their security operations center. So network security monitoring, they've outsourced it. And and I have said to our joint client many times, how do you know you're getting your money's worth? And the way we've chosen to do that is every year we conduct a pen test to, just check defenses. I mean, what you normally would do a pen test for. But as part of that process, we also are on the lookout for the Security Operations Center to send alerts. Hey, somebody's scanning your network. Somebody's inside your network, rattling all the doorknobs. You ought to go check this out. But every year we do the pen test, no, we get no alerts from this network monitoring service that supposedly should be
It doesn't
monitoring.
fill you. It doesn't fill one with a warm and fuzzy feeling of confidence,
No.
does
And
it?
so guess what? In the last 3 years, they've changed outsourced security operations centers 3 times because going into the agreement, they tell them this is what we expect. And then months later, we do the pen test and they get
Yeah,
no
Kip.
alerts.
I honestly, I think you've identified an even tougher and worse business than being an MSP, which is being an outsourced security operations center. I don't. It's part of me almost like I get why the market wants to do outsourced
Sure.
SOCs, but like I don't think that I'm not convinced the concept is sound.
There is economic disincentives in play for that whole thing to work. But I think the big reason why it's happening is because it's checkbox security. It's security theater.
Well,
Like I've done it.
I
It
mean
doesn't
that
do
is
anything, but I can say I did it.
no, and I think that is correct, and I think there's certain things I think you just have to do yourself
If you can, if you
you
can.
can.
But anyway, so I think lacking a cohesive framework testing the claims that these outsourcers are making is something that you should be thinking about. That's what we think about. Also, I think that going into the outsourcing arrangement, you need to reserve certain testing in the contract,
You do.
right?
Audit
I mean,
rights.
you have
Audit. I mean,
audit rights.
an audit isn't even. I mean, yes, the generalized phrase is audit right, but
Yep.
you need to be absolutely clear. And ideally, you would even build in things like, one, we don't have to tell you when we're testing,
Yep.
and two, you could also build in, if you don't already have it in there, to avoid arguments. I would build in, if we test and you don't notice, we at least have the option of canceling without further obligations, and possibly even request a refund if it's depending upon how you've paid. I mean, I think these are all things to consider. And I think also, Kip, you're 100% right. The testing, I think, is really, really critical here, because there's no other way to do it,
No,
right?
it's
If
a
all
black
you
box.
do is, it's a black box. If all you do is say, hey, if all you do is give a security questionnaire and accept the signed BAA, you don't really know.
No, you don't. Not until something awful happens, and then you're MTL.
Yeah.
Right?
Then
you're
you are.
MTL filing a complaint. And then, the other aspect of this too is, this is all, and I think this is where CISOs really struggle, is when you outsource something, you no longer have direct observation. You don't control how that work is done, which is really important, because if I say I'm going to encrypt this data, well, how you encrypt it matters.
Yep.
Right? but I don't get to see that when I outsource something. So it starts to feel like super abstract, super ethereal, and I kind of like I'm grasping at air going, how do I do this? And you have to do it through a contract, and that contract has to be really well done in advance. And so what I have to do as a CISO is I have to get I have to develop a very good working relationship with the contracts manager at the company that I'm working with, so that I can make sure that the audit rights I need are in those documents, because the contracts manager may not realize that they need to be in there.
Yeah, and I think, as we now truly do begin to wrap up here, I think the bottom line from this case is simple. Contracts matter, right?
Yeah.
When the excrement hits the rotary air impeller, the BAA
Another face plant. I can't believe you
Yeah.
used that.
the BAA is not just a compliance checkbox, right? It's
Mm-mm.
this critical risk management tool that defines who does what, who pays for what, and what happens when things go wrong. And look, there are many legal and regulatory consequences to a data breach. That's not news, right? Everybody
No.
knows that. But with adherence to contractual obligations and appropriate communications, a breach of contract claim doesn't have to be one of them. There doesn't have to be breaches within breaches.
Right. No, there doesn't have to be. So, all right. Great. So very well said, Jake. And I guess that does wrap up this episode of the Cyber Risk Management Podcast. So today we discussed a very instructive lawsuit that's going on between a HIPAA-covered entity and its business associate, and it followed a ransomware attack. And we never even talked about the ransomware attack. And look,
It
how I
doesn't matter.
stumbled
It
around.
almost doesn't matter.
I know. We covered the importance of clear business associate agreements, BAAs, incident response obligations, indemnification, vendor risk management, all that. And by the way, before we close this out, Jake, I want to say that one thing you taught me about third-party risk management is bucketizing, or like categorizing, right? Don't treat them all equally. Put them into
goodness, no.
categories, right? Like
Yes.
who's really most important, who can really mess up our day, and put extra scrutiny on them.
Yeah.
And anyway, we'll talk about that some other time.
We will. But now, Kip, at the risk of adding, even though you tried to wrap it up, at the risk of adding a few more minutes, I do want to say now that
Okay.
Well, I'll wrap it up like this. The company that delivers your water to the water jugs does not need to be dealt with in the same way that the company that is monitoring your 24/7 SOC. Put another way, you may have a lot of vendors, and you may be thinking, well, there's no way I can do comprehensive cyber risk and vendor risk management on all of them. You probably don't need to.
No, you don't
but
need
you
to.
need to put them in buckets and categorize them. So, okay, now, Kip.
All right. Thank you, everybody, for being here, and we'll see you next time.
See you next time.